Okay, welcome. And my name is Joseph Glazebrook. I'm an attorney. I primarily practice immigration law now, but for about 10 years or so, I did criminal defense, and I still have a fair amount of expertise in this field. I wanted to make a video because a lot of the content you see out there on social media, even in mainstream media, including especially like court TV, is pretty biased in its coverage of the Kyle Rittenhouse case. And based upon my interactions with people, I felt that there's quite a vast gap between reality and what's being talked about in this case. So I wanted to make a quick video, hopefully it won't be too long, dealing with a few key issues. First of all, if you watch the trial today is Wednesday, November 10th. If you watch the trial today, it was a circus. I mean, Judge Schrader, who's the presiding judge, he has completely lost control of his courtroom. He is I mean, maybe that's not the right way to say it. He's in control, but he's not being a judge. He's being just a very blatant, one-sided judge, I guess. Basically, if you watched today, it was a disaster. I mean, the judge yelled at the prosecutor, which, that happens from time to time, but this was about something that really didn't deserve yelling. I mean, frankly, okay, I can go into detail about that issue later, but, basically today there was a lot of drama, and it was an interesting day. So, first of all, I just very briefly want to go over a couple of basic concepts that you need to keep in mind when you watch this trial. I might do a longer video about these issues, but my word of the day for anybody watching is recklessness. Recklessness is the state of mind that is required to prove several of the charges. Mr. Rittenhouse is facing, I can't remember, I think it's 6 total charges. I think the 7th charge, actually the 6th, the additional charge was a curfew charge that has been dismissed now. So he's only facing 6 charges now. One of them is possession of a weapon by somebody under the age of 18, which is a misdemeanor. And the other 5 are felonies dealing with the use of a firearm, and 2 of them are intentional murder. One of them is a reckless homicide. And then there's 2 counts of reckless use of a firearm. So, in fact, let me just double check that. 1 is reckless homicide. Count 2 is reckless endangerment of safety. Count 3 is intentional homicide. Count 4 is reckless endangering of safety. And then count 5 is, count 4 is attempted first-degree intentional murder, intentional homicide, and count 5 is reckless endangering safety. So we have 1 intentional murder, 1 attempted intentional murder, 1 reckless homicide, 1 and then 2 counts of reckless endangering of safety, which is basically using a firearm in a way that's inherently dangerous, even if it doesn't actually hit anybody or it's not intended to hit somebody. For 3 of those, and by the way, these are so the reckless endangering of safety is there's no minimum and the maximum is 5 years. For the intentional homicide, the maximum is I'm sorry, I missed it. Okay, for intentional homicide, it's life in prison. In attempted intentional homicide is up to 60 years. For reckless homicide, it's up to 60 years. For reckless endangering of safety, it's up to 12 years, 6 months. And then for the misdemeanor, it's 9 months. So depending on what he gets convicted of, there's a range of possible sentences. But the word of the day is reckless because 3 of these 5 charges deal with recklessness. And frankly, when we talk about self-defense, which we will do in just a minute, recklessness is a different standard than intentional murder. In fact, there's, for simplification, there's really just 4 states of mind that we use in the law. 1 is intentionality, meaning your goal is to carry out the action. The action that you're engaging in has a goal, and your intent is to carry out that goal. That's intentionality. So if you intend for somebody to die as a result of your action, that's intentional murder. The second highest one is knowing, which means that maybe you don't intend for that result to happen, but you know it's going to happen because of what you're doing, and you do it anyway. That's knowing. The third one over is recklessness. We'll come back to that one. And the fourth one over is negligence. And this is the lowest one other than something called strict liability, which we don't need to talk about. And negligence is basically just means a mistaken accident. Well, not quite accidental, but you've made a mistake. You've fallen short of an expectation imposed upon you either by society or by the law or whatever. And because of you falling short of that expectation, you cause somebody's death or cause the result of whatever crime is being charged. You see negligent homicide sometimes. And then you have this category, which is recklessness. Recklessness means that you engage in an action that is so inherently likely to cause the harm that's being discussed, in this case, the injury or death of another person, that you should have known better than to do it, but you did it anyway, and you recklessly engaged in this conduct, and perhaps it caused that harm. We're in reckless territory, which is traditionally it's considered well, we don't need to go into details about the history of general intent versus specific intent, but traditionally this type of crime is easier to prove than intentional crimes. Intentional crimes, for example, theft. I intended to take the object that was stolen and keep it for myself. That would be theft. You have to prove my state of mind that I wanted to possess that thing forever or, permanently. Recklessness can be things like reckless driving is a great example. You can be convicted of a misdemeanor reckless driving charge in most jurisdictions if you drive in a manner that disregards safety to others. You don't intend to harm anybody else. You don't know for a fact that somebody else is going to be harmed by your conduct, but you should know better that your conduct could likely cause that harm, and so it's considered reckless driving, okay? Similarly, in this context, the state doesn't have to prove that Kyle Rittenhouse intended anybody to die, or even that he knew somebody was going to die as a result of his conduct. The state only needs to prove recklessness, which is that he should have known that what he was up to would lead to, or could likely lead to harm, and then prove that, in fact, it did lead to harm. So it's a lot easier to prove than an intentional act. Now, self-defense comes up in this case a lot, and we're going to talk about that real quick. The Wisconsin legislature has codified or put into law a self-defense statute. Now, this is a very complicated statute. I've read through it completely. I'm going to try to paraphrase it a little bit. In general, this is Wisconsin Code 939.48. A person is privileged to threaten or intentionally use force against another person for the purpose of preventing or terminating what the person reasonably believes to be unlawful interference with his or her person by that other person. And there's another provision later on in the statute that gives them the right to do that on behalf of third persons or property. So in general, to summarize, the rule is you can use force to prevent somebody else's use of force upon you, upon a third party that would, and the law says that would share, if you were in their position, you would have the right of self-defense, so you can use it for a third party, and for property. And the property stuff gets interesting. We'll get into that in just a second. But then it says, and real quick before I move on, it says the force has to be what the person reasonably believed. So not only does the person have to actually believe that, they have to believe that the person is about to use force against them, it has to be reasonable, which means it has to be objectively what somebody in that position would feel reasonably to do. And it can't be unreasonable. So if you are 200 feet away from somebody who's got a baseball bat and they're like, I'm going to hit you, well, you can't use force from 200 feet away to harm that person because it's unreasonable to assume they could hit you. All right. So there's a lot of, this is sort of what we call the entry-level force threshold about when you're protected in your use of force generally. But there's another section of this self-defense law, and it says that your force can only be intended or likely to cause death or great bodily harm if you reasonably believe that such force is necessary to prevent imminent death or great bodily harm to yourself. So deadly force is authorized in one and only one situation: if you reasonably believe that you are subject to imminent great bodily harm or death as a result of the other person's force. So if the other person's merely threatening to punch you, that really probably doesn't qualify, because a punch is going to cause, at most, some lesser degree of harm than death or great bodily harm. Great bodily harm, I assume, if it's anything like Iowa, where I'm at, means an injury that is capable of causing death or causing a body part or part of your body or a system of your body to stop functioning. Maybe in Wisconsin it's defined a little bit differently, but we can assume there's a high threshold for how you define great bodily harm versus mere bodily harm. So there's bodily harm, great bodily harm. Bodily harm is just any injury at all. Great bodily harm is a higher type of injury that's like a permanent injury or a serious injury that could threaten your life. All right. So you can only use deadly force if deadly force essentially is being used against you, and you can't really use that to defend property. We'll talk about the property more in a second, but I just want to get that general provision out of the way, okay? So what happens is, what if you go up to somebody with a gun and punch them in the face? Okay. You've threatened them, and then let's say they're now threatened by you, and they want to defend themselves against you, and you have a gun, and what if they went up and punched you back? Well, they would be protected by the self-defense law, okay? And then could you turn up and say, okay, well, now he's attacking me, now I can shoot him? No, you can't do that for two reasons. First of all, just in general, what we talked about, there has been no escalation of deadly force on the other side of this encounter. And secondly, there's a second section of this law, and it's section 2, actually. I'm gonna come back to another subsection in just a minute, but section 2, I just read section 1. Section 2 says a person who engages in unlawful conduct of a type likely to provoke others to attack him or her, and thereby does provoke an attack, is not entitled to claim self-defense or the privilege of self-defense against such an attack, except when the attack which ensues is the type causing the person engaging in the unlawful conduct to reasonably believe that he is or she is in imminent danger of death or great bodily harm. So basically, like I just said, if you provoke somebody unlawfully, you go up and punch them out of the blue, and then they punch you back, you can't use their punching you back as an excuse to escalate to deadly force. Now, if you engaged in non-deadly force wrongfully, illegally against them, and they engaged in deadly force back against you, then the self-defense kicks in again, and you can use deadly force in response. All right. Couple other things real quick. First of all, there's a whole section in here that says that basically if you're in your house or your own business or your own motor vehicle, then there's a presumption that any use of deadly force is reasonable. Okay? So basically you get a bit of a leeway if you're in your house or whatever and you have to use deadly force. The courts are going to start with the assumption that you probably used deadly force reasonably, and it's basically up to the state then to rebut that presumption and say your force was unreasonable. Okay? So that's the subsection in section 1. Now, that doesn't apply here because Rittenhouse was not in his house, his motor vehicle, or his business at the time of any of these incidents. I think he was in a gas station parking lot and in the street. So that is not going to apply no matter how you slice it. There's a lot of testimony that seemed to be about that, but it just doesn't apply here. Okay, so the next section deals with... one other thing real quick. I wanted to mention that this provocation section that I just read, that you can't unlawfully engage in a conduct likely to provoke others to attack you and then expect to be entitled to claim self-defense. All right, that section defines unlawful as either something prohibited by criminal law or something that's tortious, which means it's a tort. A tort is a lawsuit based upon harming somebody else. It could be something like a civil assault claim or even a negligence claim, or a trespass claim, or something like that. So basically what I'm saying is there's a very broad definition of what is unlawful in terms of the provocation language here. And basically what that means is that, if you do something to start a fight, unless you're absolutely legally authorized to do that somehow, let's say somebody broke into your house, you could probably do it then. You're not going to get a lot of protection under the self-defense statute if you provoke the fight. And then there's a question about who really provoked the fight. In this case, there's going to be a battle about whether Rittenhouse provoked the fight by, chasing somebody down, arguably, and raising his gun at the person, which provokes that person to defend themselves by attacking Kyle Rittenhouse. And if that happens, then Kyle Rittenhouse is not entitled to use deadly force. He's not even protected under the general self-defense statute unless the person escalates their force from non-deadly force to deadly force. And so if the state succeeds at, and I will get to what I think about that in a second, at proving that a person used force in response to Rittenhouse's use of force, which, by the way, pointing a gun at somebody is, according to this subsection, a person who engages in unlawful conduct, it's definitely unlawful to do that, of a type likely to provoke others to attack him. If somebody points a gun at you, that's the type of thing that's very likely to provoke an attack. So the question is, did Rittenhouse point his gun at somebody before they physically encountered him? And there's four instances where we need to look into that. And we will in just a second. And that's the most important part of this self-defense statute, is this provocation language. It's actually, I think, a very well-written statute. All right, so just real quick to finish this off, defense, excuse me. So you can, this applies to third parties, except that in other words, you can defend a third party from harm if the person in those shoes would have been entitled to claim self-defense in your shoes. But generally speaking, it doesn't say anything here about whether that can escalate to deadly force. I suppose it potentially could if the person was using deadly force against the third party. But it's a little bit unclear. The more clear section is the other one here, which says that if you accidentally kill somebody in your self-defense against target A, let's say you accidentally shoot target B, you're still privileged with self-defense unless it can be shown that your unintentional killing of target B is reckless homicide or homicide by negligent handling of dangerous weapons or something like that. So basically, you're excused by self-defense even if you miss your target unless you are reckless. Easy enough. All right. And finally, a person is privileged to use force against another to prevent the person from committing suicide. That's easy enough. And then there's another whole code section, defense of property. Again, so this is 939.49. Person is privileged to threaten or intentionally use force against another for the purpose of preventing or terminating what the person reasonably believes to be an unlawful interference with the person's property. Only such degree of force or threat thereof may be intentionally be used as the actor reasonably believes is necessary to prevent or terminate the interference. It is not reasonable to intentionally use force intended or likely to cause death or great bodily harm for the sole purpose of defense of one's property. Okay? So nobody can, in this case, can ever claim that defending property entitles them to shoot and kill somebody else. That's deadly force. That is just not allowed. All right? And then there's another subsection that says you can actually use defensive property of another person if you're the person's agent or the person's employee or something like that. And arguably, Rittenhouse was, let's, for the sake of argument, say he was this agent of this car place. He could have used some manner of non-lethal force to defend that car property. But what he could never do, according to this statute, is use deadly force to defend the car property. And both areas where the shootings occurred were not next to that property anyway, so it really doesn't apply. Really what I'm getting at, to summarize, is what applies here is that you can use self-defense if you are threatened with force or defensive property, but in this case, really, if you're threatened with force. You can use force to prevent that force from being applied to you. You can escalate to deadly force only if the other person is using deadly force, and you can't even do any of that if you provoke the attack unless the person responds with a higher level of force. Basically, if you unlawfully start an attack with non-deadly force and the person responds with deadly force, then finally you can use deadly force. A little bit complicated, but really you need to look at that if you're going to look at this case, because any analysis of the Rittenhouse case without understanding this self-defense framework is trash. It is not worth your time. If you're listening to a YouTube video of somebody talking about, well, self-defense, Second Amendment, blah, 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 without analyzing this statute, they don't know what the hell they're talking about, and you should turn off their video immediately and watch something that is rational. Okay. That is self-defense. Now, I want to go back to the charges briefly, and then we're going to talk about what happened at court today, and I'm going to try to wrap this video up relatively quickly here, so thank you for your patience. So Rittenhouse is charged with 6 counts. Now, he had a 7th, which was a curfew thing, but the judge said you can't go ahead with that because there wasn't enough evidence to prove that. It's fine. I think it was strategically wise not to worry about that because, so here's the deal. You remember when I was reading the self-defense statute, I said a person who engages in unlawful conduct of a type likely to provoke others to attack him. Okay? Well, what does unlawful conduct mean? Well, it could mean assaulting somebody, but it could also mean illegally carrying around an illegal firearm. All right? It could be. I mean, we'll see what the jury thinks, but count 6, possession of a dangerous weapon by a person under 18. Rittenhouse was under 18 when all this happened. For every second of this incident, Rittenhouse's possession of his AR-15, which he illegally purchased through a straw purchase, was unlawful under Wisconsin law. It is a Class A misdemeanor with possible imprisonment of up to 9 months. And I believe he will get convicted of that, regardless of anything else in this case. I think he will get convicted of that. He'll probably pay a fine or whatever, but he'll probably get convicted of that, all right? Now, if he was walking around unlawfully with a gun, then the question the jury has to consider is not whether he was unlawfully provoking anybody, because it's clear he was acting unlawfully the whole time. The question is whether he actually provoked somebody. So if he provoked somebody to attack him somehow, by being there with a gun, by aiming the gun, by anything with this gun, then his self-defense right is extinguished completely. Now, as I said earlier, there's 3 counts that deal with recklessness, this 3rd out of 4 levels of mental culpability. But there's 2 counts that deal with intentionality. And let me just say this. Self-defense is considered a justification defense. Basically, it says, even if you did the crime that's being alleged, you were justified in doing that crime, and therefore we're going to find you not guilty of that crime, even though you did the things that constitute that crime. And that lines up very nicely with an intentional act. Okay, an intentional act is you meant to do it, it happened, and then your self-defense is, but I was entitled to do it. Okay, I meant to do it, I was entitled to do it, no problem. So Rittenhouse has argued, and his attorneys will continue to argue that basically that any type of force that was used by Rittenhouse against at least Huber and the other person here that with the attempt charge is Grosskreutz. The Rittenhouse team is arguing that the 2 acts there, these are the acts that happened in the street, by the way, not the act that happened back at the gas station. That's Rosenbaum. In the street, the defense is arguing that, yes, he shot these people, and yes, it was on purpose, but he was entitled to do so because he reasonably believed that they were about to use force against him, and frankly, they're going to have to argue that it was deadly force. I think maybe the skateboard guy, Huber, you can make that argument that a skateboard could have been deadly force. They've kind of hinted at this argument that, if there was any type of possibility that the person could eventually disarm Kyle and use his gun against him, that he was entitled to shoot them before that happened, and that is simply a misreading of the law. That would almost never be authorized because the law says that you have to be imminently in danger of death, and merely a person lunging towards you doesn't mean that they're going to take your gun and shoot you. It means they might knock you over and run away, or it means they might knock you over and hit you in the head and then run away, or it means they might try to disarm you and hold you at gunpoint. There's so many different things that could mean, and it is not reasonable to assume, in my opinion, to assume that somebody is going to disarm you and shoot you imminently. Maybe eventually. Maybe you could argue that left to his own device, after 20 seconds of, beating me and then unstrapping my gun strap, somehow disconnecting it from the gun, whatever, and then taking it, picking it up, loading it, aiming it, eventually he could have shot me. That I could buy. But the idea of imminent death is a little harder. Now, I will say that the jury is probably not going to engage in that technical level of analysis. They're probably just going to say, well, this guy was literally attacking him. They're going to decide whether Rittenhouse provoked the attack or not, I think. I mean, maybe they'll disregard that too. We'll see. But I think there's a high likelihood that, at least with regard to these intentional homicides, the jury will simply say, well, even though technically Rittenhouse was not entitled to use deadly force, he was under attack and he could have died eventually in this encounter. And so the jury might just kind of play a shortcut and just say, well, we're going to excuse that. And I can understand that. I don't agree with that, but I can understand that. But there's 3 counts of reckless behavior here, and this is so important. You don't have to mean to kill somebody to be guilty of reckless homicide. I'll get to the actual testimony in just a minute, but in order to be guilty of reckless homicide, you merely need to have some action that shows a disregard for the safety of others. There's no question that he caused a homicide, that he took the life of another person. There's a question about whether his actions were reasonable. On the one hand, were they reasonable? On the other hand, were they reckless? And I think actually the state has done a pretty good job laying out recklessness. Recklessness kind of gets around that self-defense claim. I mean, you can still have a self-defense claim against a reckless homicide charge, I suppose. But it's really just casting a narrative. It's not. It doesn't work. It doesn't line up perfectly, if that makes sense. In an intentional homicide, you have a claim that the person meant to shoot the person by the state, and you have the defense coming in saying, but it's justified. It's okay. Complete symmetry between those two positions. In a reckless homicide, you have an asymmetrical claim by the state that this person acted without regard for the safety of others. This person lied about who he was, where he was from, how old he was, had an illegal firearm, crossed state lines, has numerous instances throughout the evening of him antagonizing protesters and saying things that suggest he was out for some sort of unscrupulous activity, and then the judge has really limited the amount of that testimony. I mean, frankly, if I'm being honest, I don't agree with the judge in some of this, but the judge kept out a whole lot of stuff that strongly indicated, in my opinion, that Rittenhouse intended to go there and get into a fight with these protesters. I mean, he was hanging out with the Boogaloo Boys in a bar. He was cavorting with white nationalists and people who are dead set opposed to Black Lives Matter in a content-oriented way. In other words, they were opposed to the views of those protesters and had an antagonistic relationship with that cause. And he has all these posts on TikTok and stuff about how he wanted to be famous and how he wanted to mess things up and fuck shit up, and I don't know all the exact words he used, but there's a lot of phrases like that a lot of it was kept out of the jury's consideration. So the jury's not going to hear all that, but I still think the state has done a great job showing he lied, he was dishonest about being a medic, dishonest about his intention being to offer medical services, reckless, needless carrying around of a military-style assault rifle, which was illegal, going into the crowd repeatedly, even though the crowd was far away from the property he was allegedly protecting. All this stuff, I really strongly believe, demonstrates at the very least that Rittenhouse was reckless. And so if I were in the jury, I would absolutely be leaning strongly towards a reckless homicide conviction right now. The problem is I'm not on the jury. I think what's probably going to happen is that the jury is going to have a division within it. We'll talk about that in a second. So the point that I was making is recklessness has a lot of factors. It's like a factual determination about whether somebody was disregarding safety by lying and having a dangerous weapon and going into danger voluntarily and antagonizing the protesters and being there illegally and being out past curfew and not having something that's more reasonable for self-protection rather than a offensive weapon. There's a lot of factors that go into whether somebody is acting recklessly with a gun, And I think the state kind of snuck in some evidence about he's the only person that actually shot somebody that night. There's 20 or 30 other guns out there, some of which were being shot generally, but he's the only person that actually shot anybody, certainly the only person who killed anybody. Anyway, so there's a lot of factors. It's a very complicated analysis, and it's really up to the jury about whether they think that's a disregard of safety, essentially. And it's a very complicated kind of, think of it as a thicker, more complicated idea that's more nebulous, recklessness. Self-defense is a very straightforward defense, usually thinking about it against an intentional claim. So when you line it up against this more nebulous recklessness claim, really what you're doing, you're not saying you're entitled to go around recklessly homiciding people. That's not what self-defense is. Self-defense is I acted on purpose, reasonably, not recklessly. So it is technically a defense to reckless homicide, but it really doesn't line up very well. And essentially what it is, instead of being like I did this, but I'm justified in doing this, it's really a battle of narratives. The battle is between whether the state's discussion about Kyle Rittenhouse's unsafe behavior prevails, or whether the defense strategy of saying it was reasonable for him to go out into that crowd and walk around with a gun and point it at people and expect not to have any physical resistance to that. And so basically, that battle of narratives, I think the state has the much stronger hand in that particular battle. I think it's very clear, in my opinion, that Kyle Rittenhouse acted recklessly. But I'm not a juror, and the jurors can make a different decision. And the problem is going to be, from a prosecutorial standpoint, reasonable doubt. So this is the kicker here. I mean, if the jury's like, well, I think he was pretty reckless, but I'm not absolutely sure he was being reckless. Maybe he was being reasonable and I just didn't get all the facts, whatever. The jury might say, well, tie goes to the defendant. And it, frankly, more than a tie goes to the defendant in criminal cases. It's beyond a reasonable doubt. That means you have to be absolutely pretty much solidly convinced of the thing that's trying to be proved. And if you have some doubts, and if they're not crazy, if they're reasonable, you should acquit. As a defense attorney, that was my job, to highlight that. I think that this case, let me talk about the actual evidence now and how the case is going, and then we'll talk a little bit about the judge and what's going to happen next. This case arguably got off to a slow start. Some of the state's witnesses were not the best witnesses in the world. I remember there was a line of testimony regarding Mr. Grosskreutz, I think it was, and the defense somehow, even though the prosecutor can't ask the equivalent questions of Mr. Rittenhouse, the defense was able to ask an effective line of questions about Grosskreutz's association with revolutionary politics, basically, and the idea that, is this sort of really, really radical politics that probably alienated the jury. Probably said, well, I kind of like this guy who's he's a goody two-shoes outdoorsman, health instructor and physical trainer or something, outdoorsman, trainer, guide, something, who was there and seemed reasonable. But then the defense got in there. It's like, well, you had a gun, right? Well, yeah, I had it in the small of my back. I pulled it out, and eventually I pointed it at his head. And yes, I was a revolutionary politics advocate, so I wasn't as neutral as I claimed on direct examination. Okay, so I think some of those, that's an example of one of the state's witnesses who adequately testified as to the facts of the case, but fell apart with some distractions about his politics, in my opinion. There was a little bit of that with some of the other witnesses as well. Some of the other witnesses were attacked for, and I haven't watched every minute of this trial. I must confess, I'm also working a day job while this trial is going on, so it's kind of, trying to balance out those things. But, there's this other guy, Richard McGinnis, who, there's a couple of the state's witnesses who are frankly very pro-gun and very pro-Rittenhouse, who the state called to establish facts. And I think they did establish those facts, but they didn't create a compelling narrative, a compelling theme. By far the state's best witness, pop quiz, who is the state's best witness? Well, it's the videos. And frankly, I think that drone video that they played today was the best witness. Because in my view, in my opinion, it showed Kyle Rittenhouse provoking the fight. I mean, I think it did, personally. Whether the jury does or not, we'll see what happens with closing arguments, but the video is the best witness for the state. As of the end of the state's case, had they proved their case beyond a reasonable doubt? Well, maybe. I mean, if I were on the jury, I think I would have voted to convict on reckless homicide. I'm not sure I would have voted. I may well not have voted to convict on the intentional homicides. Intentional and then the attempted intentional. Attempt, by the way, attempted intentional homicide is just an intentional homicide where the person doesn't die. They miss them or whatever. I'm not going to get into that, but basically it's a similar state of mind, just a different result. I think it would have been hard to convict on those intentional homicides, but on the issue of reckless homicide, I think, I personally would have felt the state had proved their case beyond a reasonable doubt that Rittenhouse acted recklessly, and his reckless behavior and his reckless shooting of his firearm led to the deaths of at least one of these people. I think, maybe different members of the jury would disagree about which ones. So I think the state's case was in trouble. I think they did a decent job. This judge, as I will discuss in a minute, is completely in the tank for the defense. As a defense attorney for many years, I have never seen anything like that. I've never had a judge who ever told the prosecution not to call somebody who died or somebody who's injured or somebody who got something stolen from them, to not call them a victim. Every single case I've ever done with a jury or otherwise, they've called him a victim, and there was no problem with it. So this weird judge says you can't call them victims. This judge is ruling against the prosecution on almost everything that happens in the case. He yelled at the prosecutor today twice. He wouldn't let him zoom in, claiming that he wasn't sure whether it changed the image on the Zoom function, which is crazy. If the judge doesn't understand that, he probably shouldn't be a judge. This judge is absolutely unprofessional. I mean, he's just completely lost it. He has no sense of objectivity. He is quoting Bible verses from the bench. He is asking, he doesn't let the parties discuss objections, but he does let the defense make objections in the form of a discussion. It's like, objection, Your Honor, the prosecutor is stating something that was not the case. It was different. That's not an objection. I mean, I don't know. I mean, some judges are loosey-goosey with that, but whenever the prosecution objects, the judge almost immediately cuts them off and overrules them. Whenever the defense objects, they don't even have to state the nature of their objection. Sometimes the judge will object for them. This afternoon, the judge was objecting to things that the prosecutor was asking without the defense attorney objecting. It was quite something. The judge is absolutely in the tank for the defense, and I think that's as clear as day. In fact, if you go to some of the right-wing coverage of this case, you'll see all these people commenting, and the phrase you keep seeing is based judge, which I looked up, and apparently that means it's like some Ben Shapiro phrase or something. It's like based in truth or whatever. It's a stupid right-wingism that nobody cares about. I mean, what they really should add is an I to that. It's a biased judge, because that's what this judge is. And I say that as a defense attorney who's actually, for years, been looking for a judge not to completely go in the tank for my guy, but to give me like a couple of favorable rulings. And the vast majority of the time, judges give the prosecutors favorable rulings. Why? because it's easier to be wrong and let the defendant appeal your wrong decision than it is to be wrong in the other direction, because the prosecutor can't appeal a lot of this stuff. Here's a fun fact about criminal law. We have a Fifth Amendment in the United States Constitution that says a person cannot be held in jeopardy more than once, double jeopardy clause, right? You can't have, if you get an acquittal, you can't be retried for the same thing, okay? Well, that even if there was something wrong with the trial, even your wrongfully obtained acquittal, if you will, is going to be almost always enough to prevent an appeal from setting your case back for trial. In other words, the defense wins, that's a done deal. But if the prosecutor wins, then there's still an appeal process because there's no double jeopardy concerns if the prosecutor wins. But there is double jeopardy concerns if the defense wins because of the acquittal that's been registered. So generally speaking, prosecutors get a little bit of the benefit of the doubt on some of these evidentiary things. But more importantly, they get, there's a procedure that they can appeal pretrial rulings. And there's a procedure, they can appeal after the fact and not be able to retry the person. They can just win the appeal and have the ability to say you were wrong, judge, but they generally can't retry a defendant. So the point is that this judge is abnormally pro-defense, and I've never seen anything like it, even from former defense attorneys who become judges and are very good judges, very thoughtful. They don't go around making objections for the defense attorneys. I have never seen anything like that. And it kind of says maybe the defense attorneys are missing some opportunities to use this judge to their advantage. Either way, though, the judge could tank the case and give the defendant a straight acquittal. That's possible. He's done a lot in that regard. But what I will say, and I will finish this video very shortly, I promise. I know I've gone on for longer than I intended. The prosecutors, let me start out. The defense attorney called Rittenhouse this morning, had him on the stand for less than 2 hours. It was actually a surprisingly short direct examination of the defendant. Defendant broke down on the stand. There's some people more on the left who are skeptics of Rittenhouse who said this was staged, this was fake, this was acting. And I can't prove it one way or the other, but my opinion is that it was not acting. I fully believe that Rittenhouse did have an emotional breakdown on the stand. He had what looked to be a panic attack on the stand. I'm not taking a side. I don't think that justifies what happened or justifies a jury giving him leniency. I just think that his emotions were real. He did kill several people. And even though I think he acted horribly in causing those deaths, I also truly think that he might feel bad about it. And at the very least, he feels nervous. There's a lot of pressure. He's in court for his life, basically, for a significant chunk of his life. And I think the moment got to him, and he was remembering things and having emotions from various different angles, and he probably had a panic attack. I don't begrudge him that. I don't think that's problematic. In some sense, yeah, I'm sure it helps his case because it gave the jury an emotional appeal rather than a factual, logical appeal. So as of that moment, you could argue, okay, the defense was making some headway there. They had their client lucidly convey his position on why it was self-defense, even though we talked about the technical reasons why that's going to be a problem. We had a defendant who got emotional and had the mother crying in the courtroom, and the jurors were, according to some of the reporting, uncomfortable in a way that could have been interpreted as being sympathetic or could be interpreted as not wanting to deal with it, something like that. So arguably the defense was ahead solidly at that point. I think they started the day at the close of the state's case ahead. The witness they called yesterday was terrible. He got absolutely massacred by the state's attorney. So I actually think they lost ground on that witness yesterday. As of this afternoon, despite the judge yelling at the prosecutor, and let's get into that in a second, I actually think overall the day concluded with the prosecutor eviscerating the progress the defense made by calling the defendant and made Kyle Rittenhouse look like he was selectively confused. He was very clear when his attorneys were asking favorable questions. But he was like, I don't know what they were thinking. I couldn't remember. I don't recall. I don't know what you mean. He wouldn't answer any of the questions. And he did a lot of this selective confusion over his cross-examination questions, which I think at first you could say, okay, well, maybe He's under a lot of pressure. He can't remember. Okay, fine. Give him 30 minutes of that confusion. But then by the end, it was ridiculous. I mean, it was like, well, when you pointed your gun at the guy, do you think maybe he was in fear for his life? And Rittenhouse was like, can you restate the question? I don't know what you mean. Can you reframe that? Well, if you point your gun at somebody, they'd reasonably be in fear for their life, right? He's like, well, I don't think so. Maybe, but who knows? Just this weird, obviously deceitful, I would argue, tone and response that you kept getting, and it was just it was too much for me. So I think that he came off as dishonest after increasingly over time. Like, it wasn't just immediate, but as he kept squirming around and avoiding answering questions and being unreasonable with his answers, I think he started to come off increasingly dishonest. I think he came off as unwilling to admit the bad facts in the case, and I think he'd be better off if he had come to a strategy of admitting some of those facts and then finding another way to argue self-defense rather than trying to deny them. Like, did you ever raise your gun at somebody? There's a video that shows him raising his gun at somebody before they charged him. And he just denied that, even though it's right there on video. And I think the jury might, if they're reasonable, if they're doing their job, might see that. We'll see. So I think he came off as unreasonable, dishonest, maybe a little bit, I think the biggest thing is the dishonesty. He was trying to be this, like, I'm just a reasonable kid who came up here and I had to shoot him. I had to. And at first, maybe the jury could buy that. But by the end of the day, I think the jury was like, well, you probably didn't have. You just certainly didn't have to go out there. Certainly didn't have to do 99% of the stuff you did that night. And if you did all that bad stuff and then at the last minute the person's attacking you and charging you and then you felt justified in shooting them, well, you kind of put yourself in that position. I think the jury might be starting to feel that way a little bit. Maybe not completely. I mean, certainly maybe not all of them. Okay? So I think Rittenhouse absolutely damaged his case by testifying, and that is why I believe the defense attorneys chose not to, after 6 hours of increasingly bad cross-examination for them, maybe 5 hours, I don't remember exactly, but from like 11 o'clock to like 4 p.m., it was a cross-examination from the state that started out a little iffy with the judge yelling at the prosecutor, but really got pretty bad for the defendant by the end. And I believe that because it got so bad and because it was so damaging, it's because of risking a bad outcome for the defendant the longer that cross-examination went on. I think the defense attorneys chose strategically not to open the door for additional questions by choosing not to redirect him, which is normally what you do when you have a witness who's just beat up by the other side, when they're savaged by the other side. Normally what you do is you recall or you redirect them. You get to ask good questions, favorable questions, friendly questions again, to clarify some of the things that the other side got you on. And the fact that they didn't do that, it's either a sign of profound arrogance by the defense attorneys, which could be. Maybe they think no damage was done, no harm, no foul, let's move on. That'd be arrogant in a way that I think is bad for their client. Or two, they reasonably, and this is reasonable, they calculated that it would be more risky to let this go on any longer, even if that means losing the ability to rehabilitate the witness a little bit. So, overall, the day was a good day for the prosecution, even though there's a lot of fireworks over this evidentiary stuff. Let me just briefly talk about that, and then I'll end the video, because I know that's what a lot of people are wondering about. Why did the prosecutor get yelled at? All right. So, in courtrooms in this country, we file motions in limine, which are requests by to the judge to either let in or exclude evidence based upon the rules of evidence. The rules of evidence are designed to facilitate relevant information into the jury in a way that doesn't, it's not unfair, it doesn't distract with things that are not really that important, doesn't get into reading people's minds or saying what somebody else said that you can't verify whether they were telling the truth. There's all this stuff, there's all these rules, and they're actually, as complicated as they are and as frustrating as they are, they're actually pretty good at helping get to the truth of what happened. Okay? So both sides use these rules to try to shape the case to fit their perspective. There's nothing unnatural about that. This judge has made some very pro-defense rulings before trial about these things, but this judge notoriously doesn't like making decisions. And earlier I commented on Facebook. He actually said, I don't really like that rule of evidence, so I'm not gonna enforce that. This judge is just completely. It's the strangest thing I've ever seen. This judge does not like to enforce the rules of evidence. He doesn't seem to understand the rules of evidence very well. I mean, he's trying to like talk his way through these evidentiary objections in open court with the jury sitting right there, and he's like trying to explain. Today he tried to introduce his own testimony about how bullets work, by the way, which is something absolutely forbidden for a judge to try to introduce facts into evidence. But he's like sitting there trying to explain evidentiary objections in the presence of the jury. And, basically in this situation what happened was he had made a prior written ruling on an issue that the state wanted to bring up, which was whether Rittenhouse had made statements after his arrest to journalists, and maybe something about taking a selfie in a bar. There's several things that came up in this discussion. The judge got pissed off because he thought the prosecutor violated his order, which said, we're not going to let this come in. Now, two things here. First of all, when a judge makes a decision about a motion in limine, this is defined as what lawyers call a preliminary ruling. It is not a final ruling, okay? What does that mean? Well, the reason that a piece of evidence may or may not come into trial sometimes depends on what happened in the trial leading up to that point. For example, if a defendant has been convicted of, let's say, misdemeanor forgery or something like that, okay, well, it's probably not relevant to the issues in it. Let's say they're on trial for assault, okay, so you get into your assault trial. And the prosecutor wants to like damage them by saying, well, he got convicted of forgery before, so probably committed the assault. Well, it's not relevant at all. Completely irrelevant. And every judge who knows the rules of evidence is going to say you can't bring up certain types of convictions like a misdemeanor forgery conviction because it doesn't relate at all to the assault. And it just makes the guy look bad, and it's just designed to inflame the jury and make them convict him even though he's not on trial for forgery, okay? However, if the defendant in the assault case takes the stand, that changes things because the defendant has put his own credibility in issue by taking the stand. And then the question becomes, does this forgery conviction, which is a crime of dishonesty, does that affect the ability of the jury to trust this witness, the defendant, in that case? Now, we don't have quite that clear of a situation in the Rittenhouse case. But what we have is, and I apologize. This case is so complicated. I don't remember the exact thing it was. I think the judge said it was some sort of propensity evidence, and it was about like whether he had said something violent or made a threat or gone around with his gun before. So I don't remember exactly. And the judge said you can't bring that up in his written ruling. But the problem is, Kyle Rittenhouse then chose to take the stand. And whenever a defendant chooses to take the stand, I got to tell you, as a defense attorney, that is something we don't like. We have to do it sometimes, but we don't like it. Why? Because if they say anything at all, that is inconsistent with basically your theory of the case, basically inconsistent with what you've asserted up to this point, that the judge has given you favorable rulings about, then suddenly you've opened the door. You have what we call opening the door. You've opened the door for something called impeachment, which means, oh, you're departing from your prior statement? Well, now the jury doesn't know which thing to believe. We have, and this is something that wouldn't happen in front of a jury, but I'm just kind of summarizing what was going on here. It's like we had a pretrial ruling by this judge that said you can't bring up your going around threatening people with a gun or saying things like you're going to be famous and so forth and so on, and Snapchatting how you want to stir things up or whatever, because that makes you look bad and it's not really relevant to whether you killed somebody. Okay, but now you've gone up on the stand and you said, I was just there to provide medical service. I'm a good boy. I didn't do anything wrong. I wouldn't do that. I would never do that. I would never, ever consider intentionally shooting somebody for the purpose of killing them I merely brought my gun as a decoration. I didn't mean to kill anybody. Okay, when he says that on the stand, as he basically did, I'm sarcastically paraphrasing, but he basically said that on the stand. Now, that creates another basis for introducing his prior acts, which are inconsistent with his testimony that he just gave. So if he said, I was a goody two-shoes, I didn't do anything wrong, I didn't mean to kill anybody, but he has a prior Snapchat or whatever it was, I don't even remember, that said, I'm here to fuck shit up, or I'm here to be packing heat and kicking ass and taking names, or whatever it was, I don't remember, doesn't matter, then suddenly that, which would normally not be relevant, is relevant to disprove what the defendant just said on the stand under oath. And having put his own credibility in issue by choosing to testify, the defendant has now opened the door by testifying inconsistently with this material evidence on this issue for the prosecutor to introduce that evidence. Now, that is how a reasonable judge would analyze that issue. And that is a reasonable judge would say, counsel, your client opened the door by testifying he was a goody two-shoes who didn't intend to kill anybody with his gun that night. And that was his choice, but now the prosecutor gets to try to contradict that because he has evidence that goes against that would have not been relevant, per se, except for the fact that he chose to testify and say something that contradicts his prior actions that were normally inadmissible. Okay? So that's how a judge would normally deal with that. A judge would normally say, it's not coming in, but unless you open the door. And then they did open the door, and then the judge would let it in. That's how it would normally go. But in this case, the judge was like, well, I didn't rule on that because I knew that it could come in if you open the door. But I'm going to say that I did rule on that, and I'm going to yell at you for introducing this evidence that's now, and the judge is not saying this, I'm saying this, that is now clearly relevant and clearly admissible for the purpose of impeaching the witness. And the judge is now saying, screw impeachment. I don't believe in the rules of evidence at all. I made a pseudo, partial, sort of touchy-feely ruling that wasn't really a ruling that said you're not supposed to, I'm leaning against letting this in, basically is what the order said. And he yelled at the prosecutor for, one, getting it in through a different method, which wasn't ruled on by the judge at all, and two, for actually listening to the judge when he said the door was left open to see if the defense opened the door. In my opinion, not only was the judge completely wrong from an evidentiary standpoint, but he was atrociously unprofessional by yelling at the prosecutor for that. And at the very least, the judge could have said, counsel, I understand what you're trying to do, and normally there might be some additional purpose that you could introduce this evidence, but in my view, it's still, on balance, too prejudicial, so I'm going to make a ruling that it's more prejudicial than probative, and instruct you to move on from your questioning and not bring this up any further than you already have. You've made your point, move on, please. The judge could have made a very pragmatic ruling like that, where he mildly disagreed with the defendant, but still made that ruling, with the prosecutor, and still made that ruling without yelling. So, in my opinion, the judge just completely went off the deep end. The judge additionally, in addition to that fiasco, had this surreal discussion about whether zooming in a video changed or altered the video in a way that was problematic from an evidentiary standpoint. First of all, everybody in the world zooms in on pictures and videos on their smartphones. And the defense attorney suggested that, and I'm trying to remember this, he said, Apple software enhances, when you zoom in, it adds pixels or adds information and uses logarithms to change the data in the video that's being depicted. Now, first of all, this is complete bullshit. When you zoom in, you are taking the pre-existing data and you are getting a bigger view of it. If you have a text, let's say you write the word 5 in a text message and you zoom in on that, you just get a dot matrixy, pixelated view of the smooth appearing from a distance letter F or whatever. So it's completely bullshit, but I love the fact that he used the word logarithm and the judge just didn't say anything. I was just like, do you guys know what a logarithm is? Clearly not. I think he meant algorithm, of course, but it's just, we had this 20-minute discussion about whether zooming in on a device distorts, or not distorts, but changes the data that you're looking at. And yet, throughout this trial, throughout every trial I've ever been a part of, it's so common for people to bring in blow-ups of like a map or of a picture or whatever. Never any problem there. But when you do it on something that's slightly technologically sophisticated, the judge is like, well, we have to have an expert come in and verify that and blah, blah, blah. And it's just this crazy discussion. I've never seen anything like it. The judge is completely off of his rocker. Anyway, let me conclude this video, finally, by saying this. I think the judge is absolutely trying to throw the case to the defense. There's a pending motion for mistrial. The defense attorneys, after that break where that yelling happened, came back and said the state did it on purpose, and therefore you should do a mistrial with prejudice, meaning you can't retry it. Say he's been placed in jeopardy under the double jeopardy clause, and the state intended to avoid an acquittal by throwing this dump trunk at the case and trying to dispose of it, and therefore you shouldn't be allowed to retry it. Okay. First of all, it's not uncommon to see a motion for a mistrial. It's pretty uncommon to see a motion for a mistrial with prejudice because they're almost never granted. And you would basically have to be able to demonstrate that the prosecutor engaged in a conspiracy to violate the rules of evidence to throw the case in a way that avoided the acquittal. So, first of all, there was no, in my view, there was no evidence of that. The prosecutor clearly demonstrated. First of all, I think it was right on the evidentiary ruling. But secondly, even if you don't agree that he was right, at the very least, he was asserting an argument in good faith, and there's no evidence whatsoever that he was trying to throw the case or avoid an acquittal so he wouldn't, basically he was trying to throw the case into a mistrial so he could avoid it going to a verdict and getting an acquittal. There's just no evidence of that. It's insane. It's a crazy and insulting motion. So I'm sure the state will come back with some good research to rebut that, and even with this crazy judge, I'd be shocked if the judge grants it. If the judge does grant it, by the way, this is one instance where the state could appeal and go back and redo the trial because there wouldn't be an acquittal. It would be a mistrial with prejudice, and then the state would have to appeal the with prejudice part and get an appellate court to say, Judge, you're crazy. There is no with prejudice. Stop this nonsense. Remanded for retrial. I mean, that's what would happen on appeal. So the state could do that. But I don't think this judge will grant that. It's pretty rare to grant a mistrial in general. The judge just spent 2 weeks of his life doing this case. They just inconvenienced a whole bunch of people and the juries and the witnesses and so forth. Judges hate mistrials. Everybody hates mistrials except for losing defendants. I don't think the judge is going to do that. What I do think is that it'll probably... we'll see how the next day or two goes. This case is going to depend completely, in my opinion, on two things. First of all, how legally accurate are the jury instructions going to be? If the jury instructions are legally accurate, after reading through the charges involved and the self-defense statute, it is my view that that will help the prosecution get a conviction for a reckless homicide, or at least a reckless endangering of safety. Which is a felony, and I think that's really important I don't think it's necessary for Rittenhouse to go to prison for the rest of his life, but I absolutely think it's necessary for him to be convicted of a felony here. He should never be able to use a gun again, ever, period. He's not somebody who needs to have a gun. Sorry, got a little distracted. Secondly, in addition to the jury instruction issue, actually, before I move on to second, if the jury instructions are legally inaccurate and they gloss over the technicalities of self-defense, and if they're inaccurate in any way that leans towards the defendant, then I think that will be a major impediment to getting even a reckless homicide conviction. All right. The second issue that I've been thinking about this entire time, on day 2 of the jury trial, I think it was, there was an alternate juror who was excused from the jury pool because he made a racially insensitive joke about Jacob Blake, the person whose death started the protest that resulted in Kyle Rittenhouse coming to Kenosha, Wisconsin in the first place. So he was excused from the jury, and I thought to myself, gosh, if a racist, obviously somebody with an agenda, obviously somebody who's not willing to look at these facts in a neutral fashion, this person was clearly just sitting around waiting if he got on the jury to acquit this guy. I think there's a huge risk in this case of there being at least one person on this 12-person jury from Kenosha, which is a very swingy part of Wisconsin. It's kind of purpley, slightly blue, but mostly purple. And I think there's a serious risk that there could be somebody with a political agenda so extreme who snuck through the jury selection process without disclosing that he'll sit there, it'll be a he, of course, he'll sit there and insist that his version of the Second Amendment and his understanding of self-defense is more important than the law. If that happens, and he refuses to change his mind, then you could get a hung jury, which would result in a non-prejudicial mistrial. He'll probably get retried. But this is such a political case, and if there's even one member of the jury that is politically interested in the result of this case, which there are hundreds of thousands, millions probably, people across the country who hold those views on either side. But it's especially important in the case of somebody who's pro-gun, anti-prosecution in this case, because there's a lot of people like me who are not a huge fan of carrying around assault rifles in the middle of a domestic situation, a non-military situation. I'm not a fan of that. Like, I understand that we have a Second Amendment, and if somebody wants to keep a hunting rifle at home to go hunting, or if they want to keep a handgun at home, that's not my choice, but I respect their choice. If you go into a chaotic situation with a military-style assault rifle, and you go in and among the crowd, away from the business that you're supposedly protecting, and you end up killing somebody, I think that is not good. I don't like those choices at all. And because of that, my view is that that I'm inclined to think that some of the actions in this case that have been presented in the evidence are indeed reckless. But I am willing, and I have always been willing, to consider whether each of these instances constitute self-defense. And frankly, I think maybe the Anthony Huber one, I'm not convinced that self-defense isn't a viable argument there. And it's not because I think that it was the right outcome for Kyle Rittenhouse to shoot Anthony Huber. It's just that I don't know for sure that he didn't feel that he was being subjected to deadly force reasonably at the time of that attack. I'm not sure. I might feel differently if I was making a 50-50, whichever side has more evidence kind of decision. But this was beyond a reasonable doubt here in a jury trial, and I'm not sure I would be at the point of beyond a reasonable doubt on that particular charge. Or the other charge, there's a charge dealing with an unknown victim who, this is count 5, first degree recklessly endangering safety. Rittenhouse shot bullets at this person who jumped over him, but then the guy ran off. They never figure out who he was. Well, I think he probably did recklessly endanger that guy, and maybe I'd vote to convict, but if they can't even find the guy, there's a lot of reasons pragmatically why I could see a jury not convicting there. So there's people like me who maybe have some skepticism about people walking around with assault rifles who can look past that and who could say, yeah, but putting that aside, looking at the situation for what it is, did his actions constitute recklessness? Did they constitute intentional homicide? And in my opinion, actually, on at least the most serious charge, there might be reasonable doubt there. So I would probably be somebody who, even though I have my opinions, I can at least come to a reasonable conclusion that maybe isn't fully in agreement with my preconceptions. But if you have somebody on the other side, forget about it. It is Second Amendment, do or die. He could have gone in there and shot 20 people without thinking about it, and there's people probably in Kenosha, Wisconsin, who'd acquit him. He could have gone in there, used the N-word himself, shot 20 people, and get acquitted by some people in Kenosha. And so the question is, did one of those crazy gun nuts sneak it onto the jury? And my suspicion, sadly, is that the odds are decent that at least one did. So then it becomes a question of, will there be enough consensus among the jurors to vote to convict? Notwithstanding that, can they find a way to compromise and say, well, fine, we won't give him the intentional homicides, but let's give him some reckless endangering safety charges, and maybe the guy will be like, fine, I'll agree to that, just to get the homicides taken off. Maybe that'll happen, and if that happens, it's not the end of the world. But it's also significantly possible that there'll be a hung jury. I think that's the most likely outcome, where the jury can't decide anything, and the judge has to declare mistrial, and then they'll retry the case. And then the third option is, will there be no conviction at all, a unanimous decision to acquit him on all charges? I don't think that's likely, because there's still that unlawful possession of a firearm charge. And somebody might be crazy enough to insist upon that, but I think 11 other jurors can cajole that. But I do think there's a significant risk of an acquittal across 5 of the 6 counts, and Rittenhouse being convicted of the misdemeanor and getting a fine. So we'll see what happens. Those are my thoughts. Again, the word of the day is recklessness. If you are listening to content out there that doesn't include the word reckless in describing the state of mind required to commit this crime, that is trash. If you're listening to content that doesn't discuss the intricacies of self-defense and the inability to provoke the situation that led to the self-defense, that is trash. Get rid of it. This is where it's at. Those are my thoughts. And if you have any comments or feedback, I'd love to hear it. Thank you for watching.